Hello, I'm Andy Allen. I'm the lead at CTSI on consumer ADR, alternative dispute resolution. Today I'm talking about why ADR approval improves the consumer landscape. And in particular, I'll be talking about ADR approval as it applies to trade associations and to approval schemes. So alternative dispute resolution for consumers has been around, or approval has been around since 2015. Initially implemented from a piece of EU legislation, the ADR directive. The EU had felt that the consumer rights were strong. There'd been a whole raft of consumer rights improvements over the last, or the few years before 2015. But consumer protection as a whole was being weakened, not by the lack of rights, but by having underutilised redress mechanisms. The consumers in many members, including the UK, felt that the court system was too expensive, too slow, or it was perceived as being too formal. Therefore, in 2015, we saw implemented into UK legislation the ADR directive as the alternative dispute resolution for consumer disputes, competent authorities and information regulations 2015. Now, the basic requirement here that protected consumers was if businesses have a dispute with a consumer that cannot be resolved between the consumer and the business is now required to signpost the consumer to an approved ADR body. And we'll talk about that more fully at the moment. All I would say is that basically, if you're a consumer and a trader, you have a dispute, the trader's internal systems are not able to resolve it, then the business needs to point you towards a approved ADR body, a body that's gone through the approval process. If they're sending you to their own trade association, which is not approved as an ADR body, then they are not compliant with the legislation, even if that trade association then sends the dispute on to a approved ADR body. As I said, we'll talk about that more fully in a moment. So in the regulated sectors, there were competent authorities set up, and all of these were the regulators. Now, the role of the competent authority is to carry out the approval, carry out an approval against criteria laid down in that legislation to ensure that any body that's carrying out consumer ADR in their sector at least meets the requirements of the regulations. Now, as we see here, there's a competent authority in most of the regulated sectors. You've got finance, law, aviation, gambling, energy, communications, and estate and letting agency regulator delivered competent authorities. Since 2015, CTSI has operated as the competent authority carrying out approvals for ADR bodies in the non-regulated sectors. So we act approving bodies in those areas where there's not a regulator to carry out those approvals. And since 2015, we've approved 35 ADR bodies running 45 different ADR schemes. Now, they cover a wide range of sectors, including some problem sectors. We've got tickets, car sales, property, retail. But I think also what must be understood is it's all consumer to business transactions, contractual transactions are covered. It's a very narrow definition of the one exception, which is health products, which are just simply products put there to protect health. So a very limited exception. Otherwise, all consumer contracts, consumer to business contracts are covered. And just to show you some of the width, we've got parking, we've got a football ombudsman, we've got a waterways and highways ombudsman, and we've got hair and beauty ADR, we've got carpet ADR, furniture ADR, so it's very, very wide. So what does ADR approval offer to the ADR body? Well, first and foremost, it shows that the process of your schemes have been audited as being effective. As I said, a lot of these ADR bodies existed prior to the approval regime, but now they have someone, us, in most circumstances, come out and audit them to show that they are effective in delivering ADR for both the consumer and the business. I said I'd talk about trade associations. So if you're a trade association and your members are, as I said, pointing to you as their trade association, and you are picking up the phone, talking to the consumer, talking to the business, trying to resolve those complaints. First, that is quite able to be ADR and meet approval criteria. Don't have to be a formal mediator or adjudicator or arbitrator, just need to be effective at resolving disputes. And secondly, and probably more importantly, if they are pointing to you, they are not compliant. If you then are approved, then all your business members become compliant with the ADR legislation. Consumers have greater trust when a scheme is approved. With reviews and trustmark type schemes, consumers are used to looking for a badge and approval of some type, and this gives consumers greater trust in your scheme. And finally here, I think, what does ADR approval offer to an ADR body? Well, CTSI now has a lot of experience, as you saw, 35 ADR bodies, 45 schemes, all approved by us. We've got a lot of experience and looking at ADR schemes, and we are able to share best practice. We're able to give you that second external opinion that you might not have from elsewhere. So what does ADR approval offer the business? Well, first and foremost, there's a lot of research done that shows that ADR can help maintain the relationship between the consumer and the business. Consumers are generally accepting that mistakes can happen, that problems can occur. What differentiates the good from the bad is then how that problem is handled, and sending a complaint. You've tried to handle it yourself, you cannot deal with it as a business to the satisfaction of the consumer, sending it to that independent third party, letting them have a look at it, letting them communicate with the consumer. Even when the consumer loses that case, for a better way of putting it, even when they lose, research shows that generally they are better placed, or have a better view of the trader for actually having made that effort. And a lot of businesses will see complaints and disputes not as a threat, but as an opportunity. Usually, it's cheaper and faster for the business to resolve a dispute using ADR than going to court. So we talked about it being, the consumers not using the court system because it seemed to be slow or expensive. Well, same for the business. It's usually cheaper or faster for the business to resolve a dispute using ADR than going to court. It may also be quicker and cheaper than continuing to try and resolve the dispute using their own internal process. There's only so far you can go using your internal process, and a small number of consumers that may not be satisfactory, and you're going around in circles. It's taking up time. It's probably taking up time at a more and more senior level. So sometimes for businesses is actually quicker and cheaper, not only than the courts, but quicker and cheaper to use ADR than continuing to try and deal with this in their own internal process. And I think finally for the business, it builds trust in the consumer when a business belongs to an approved scheme. We see lots of businesses use their membership of an approved ADR scheme in their marketing, or certainly in their complaints, in the communications around their complaints process. So what does ADR offer the consumer? Well, there are various methods of ADR, and the process is usually perceived as much less formal than the court process. The ADR process is often free to the consumer. All of CTSI's approved schemes are free to the consumer except one, which charges £12, so cheaper than the courts. The government are considering making ADR mandatory in areas that have high consumer detriment. It's not well, in some of the regulated sectors it is, but in the unregulated sectors it's not currently mandatory. One of the big weaknesses we hear aimed at the ADR approval process is that the use of ADR is not mandatory in these unregulated sectors. I know at the time of the introduction of the legislation, it was felt that to make it mandatory across all sectors, it's still the feeling is the same now, but to make it mandatory across all sectors would be too much of a burden on business and probably not necessary in some sectors. But as part of the current consultation on consumer rights, government are definitely considering making ADR mandatory in those areas that have high consumer detriment. So we may see a strengthening of what ADR offers to the consumer. And I think I would have to say, even without it being mandatory, certainly the approved bodies are genuinely reporting over the lifetime of their approval a growth in the number of businesses and consumers using their scheme. So although it's not mandatory, we are seeing more use, even without it being made mandatory in those problem sectors. The process is confidential. There's a lot of requirement towards transparency from the ADR body, but for the parties it's confidential, and it simply offers the consumer better consumer protection. If you are buying from a trader who does use approved ADR, and they should be somewhere on their website or whatever displaying that information that does use consumer ADR, then you are better protected generally than you are for one that doesn't. So further or more detailed look at the actual trader requirements. Section 19.2 of the regulations. This is what I think is the basic requirement. As I said, it applies to all businesses selling to consumers. That very small exception for health products, but I'm quite happy to generalise that to all business selling to consumers. Where a consumer and a business have exhausted all internal complaints procedures. Now let's be very clear, the internal complaints procedures does not include efforts by the trade association. So consumer and business have got to an impasse. They cannot now deal with their complaint effectively. Then the regulations require that the consumer then is informed by the business in a letter or other durable form, such as an email, A, that the business can't settle the complaint with the consumer, and B, the name and website address of an approved ADR provider that would be competent to deal with the complaint should the consumer wish to use ADR. So you see most of the ADR approved bodies are working in particular sectors, so they have that competency requirement covered. And for trade associations, there is that sort of a brand awareness, if you like, within the sector. So traders are generally aware of the trade association. They may not be aware of an approved body if it's not the trade association. So here is a need. I think here is a situation where it helps if the trade association, the recognised trade association, actually is the approved body, certainly if they are already dealing with complaints. And as I've said, it's not mandatory in this situation. So it's whether the business is obliged or willing to use ADR in this instance. We'll talk about obliged next. So we have the 19.1 of the trader requirement. Now, this is where a business is obliged to use ADR by law as I've said, we've got the regulated sectors also covered by this legislation, or more pertinent here, by the membership of a trade association. So what this is saying is if you've signed up to a trade association that says you use approved ADR, then you must then use approved ADR. The business must provide the name and website address of the approved ADR provider. Again, on the business website, if the trader has a website, or at least in the general terms and conditions of sales contracts between the business and the consumer, where such general terms and conditions exist. So if you're a member of a trade association, that membership requires you use the approved ADR, then these regulations require you to follow the regulations. A, use the ADR. B, tell the consumer which ADR you use and how to contact them. So how does an ADR body gain approval? Well, first, let's make it very clear. It's a very straightforward application process. We have a application form which we've designed to assist you along the way. But really the legislation just says, here's the criteria, we'll talk about them in a moment. Here's the criteria, tell us, CTSI, the competent authority, how you meet these criteria. Give us a reason statement about how you meet these criteria. And you can provide that if you like. What we try to do is make that more straightforward, sort of get the thought process going by having our own application form. What I would say to anyone thinking about approval is speak to us first. How we tend to deal with approval is we have a long conversation. I don't mean a long conversation at one point, but over a period of time, a conversation that identifies any key issues that are going to really become a stumbling block. We don't waste your time. We have that conversation very, very early on before we start auditing, before we start charging. The audit is chargeable. So before we start any of that, to make sure we're not wasting each other's time. Then we give you advice on how to go through the process, and as we said previously, how some of the criteria can be met drawing from our experience dealing with other ADR bodies. And then once we've got to the point of submitting an application form, we then come out and audit, and we then give you a report on that audit. You've either passed or failed. If you've failed, then we'll give you doesn't generally happen, but because of the long conversation going on ahead. But if you have, then we give you advice on how to then in future meet the requirements. What are the requirements? Well, the ADR scheme must be so provided in relation to a domestic or cross-border dispute between a consumer and a trader. Legislation doesn't have to deal with domestic or cross-border, and cross-border, but you have to deal with one or the other, possibly both. It has to be accessible. So we come and look at your website, for example. We come and look at how vulnerable consumers can submit a complaint, things like that. It must be impartial and independent, and you must show that you have expertise in the sector. You must show that competency in the sector. The scheme must have a conflict of interest policy, and it must be able to show how it would deal with the conflict once one arose. The scheme must be transparent. So the requirements for information on your website, there's requirements for the provision of information at different parts of the process. It must be effective. You must be effective at dealing with complaints. It must be fair. It must offer legality, so decisions must comply with, as a minimum, with the solution that would be imposed if the consumer was enforcing their consumer law rights. And the scheme must clearly show any grounds for refusing to handle a dispute. So you're allowed, in certain circumstances, to not take a dispute. That might be because the complainant company is not a member. It might be you might have financial boundaries. So you might have, we won't deal with a complaint above £10,000 for as an example. You might not want to deal with vexatious complaints. And all of these things just need to be laid out in the form's process paperwork. And all these requirements are in Schedule 3 of the legislation. So we've talked about the application form, we've talked about a reason statement. Part of what we then do is look at your supporting evidence and documents. And I think two particular situations there. You're either a scheme that's already operating before approval, and therefore you can show us the supporting evidence, you can show us the supporting documentation. You may have made changes to meet the requirements, so you haven't actually got a history of following that process. You may be a new scheme, so you therefore again haven't got that history. In those last two circumstances, what we'll tend to do is your paper process, is compliant with the legislation, and then we'll grant approval on the understanding that will come out at 3 months or 6 months, whatever is appropriate, and bearing in mind the volume of complaints. 3 months or 6 months, and we'll check that actually there is adherence to what you had written in your process document. Discussion all along the way. You submit your documents, we review them, we then feed back, and it's a very two-way process. Your hand is held throughout, and actually the feedback about the support available from CTSI through the application is always very, 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 very positive. Now there are charges. The legislation says that we can charge £750 a day for our work. We do a lot of work up until the point where we feel we can start charging. We try and put as much into that as possible, so that when you make your actual application, it can then go through the process as swiftly as possible, and charges minimised to you. Complexity of the scheme schemes are varied. The size of the schemes are varied, so it's hard to say what it costs in terms of fitting one fee, but we tend to be anything between £1,700 and £3,000 for the initial approval, and there are subsequent, we'll talk about in a moment, there are subsequent biannual visits, and they cost anything between £750 to £1,500 every 2 years to make sure you stay compliant. So yes, the ongoing monitoring. Every year you're required to put an annual report, submit it to us, and put it on your website. That's all the information is laid out in Schedule 5. It's basically the core parts of the approval criteria, and it allows us to have a look and make sure, certainly as you're reporting it, that you are still compliant in key areas. And then biannual report in Schedule 6, a little bit more detail every 2 years, and it's that point we would not only review the report, but we come and actually check that what you're saying is being done. And a note on the compliance review and the initial approval at the moment. What we found was we need a site visit. We generally need a site visit for both of those processes, the approval and the compliance review every 2 years. We found that certainly in the compliance review, things slip, generally not on purpose. Things slip. The most common cause for things slipping is a change in personnel. So the staff that were there at the approval process point have moved on, and the new staff haven't picked up. Haven't picked up the requirements of the legislation. The things have just slipped. So we found that on-site visits are important. However, obviously at the moment we are living in a COVID-19 world. So at the moment we are doing both the approval and the compliance visit where possible remotely. We've been able to do most of them that way, but there is always a big rider that we will, maintain the right to come out and check once COVID requirements are lessened. The other time you might see us, if you're approved, is ad hoc visits and checks, and these are generally led by consumer complaints or an indication of non-compliance from somebody else, maybe from government or from another ADR body. Not a massive amount, we don't do a massive amount of these, but there are certain sectors where we do see a few consumer complaints. No one would be surprised to know we get consumer complaints about ADR in the parking sector, for example. So We do investigate complaints. They're a very useful source of information for us. And if we, in that investigation, we do find something that we're not happy with, we'll seek clarification from the ADR body, and if necessary, seek changes. So, in summary, ADR approval benefits both the consumer and the business. Businesses, it helps maintain relationships. Consumers, it's faster, cheaper, less formal than the court processes, and fundamentally consumers are more likely and are becoming even more likely to use it than they would the court process. In cases of disputes, all businesses are required to highlight an approved ADR body. Again, I finally reiterate, at the point of dispute, the consumer and the trader cannot sort it out amongst themselves. The law requires them to signpost to an approved ADR body. If they're signposting to you and you are not approved, that trader is not compliant with the legislation. And finally, the ADR approval process is very straightforward, and CTSI will help you through it. We will hold your hands all the way through. We will do everything we can to reduce the charges at the end. And as I said, the feedback we get is actually going through the approval process is useful to the body, and they appreciate the support and the feedback they get from CTSI along the way. I think it would be fair to say they always thought it was going to be more painful than it actually was. And that's the end. Thank you for your time today. If you have any questions, then please contact our operational team. The details are there. Thank you.